For landlords in California, staying current with new legislation is a key part of managing your properties effectively. For 2026, a new set of laws took effect on January 1st, introducing important changes to your operation and financial responsibilities. No one change is devastating in itself, but it continues the continual erosion of landlord rights in California and makes using a professional property manager even more desirable to avoid excess liability. In this video, we're diving into 5 key legislative areas changing in 2026. We'll cover new requirements for appliances, upcoming policy on climate controls, new procedures for handling security deposits, and the next generation of rent control being proposed. This is what you need to know to manage your investments effectively, so watch to the end to make sure you know about all the important new laws affecting you. And don't forget that if you own a condo or a 3 or more unit property, the elevated elements, inspection and compliance laws are now in effect. You may be facing steep fines if your building is not in compliance. Since I've already made a video on that topic, I'm not going to cover it here, but you can see a link in the description for that video or look in my playlist, Laws Affecting California Investors. The Habitability Squeeze Part 1, Your Appliances, are now theirs. Let's begin with one of the most direct changes affecting your properties, Assembly Bill 628, which concerns appliances and rental units. Effective January 1st, 2026, for any new lease, lease renewal, or written lease amendment, landlords will be legally required to provide and maintain a working stove and a working refrigerator. For years, providing these appliances was a business decision, an amenity you could offer to attract tenants or just justify a higher rent. Now the state has made this a standard requirement. These appliances are now considered a component of habitability, placing them in the same legal category as plumbing and heating. The significant change here extends beyond the initial cost of purchasing and installing these appliances. The greater consideration is the ongoing responsibility. Before this bill, a broken fridge was an inconvenience to be addressed. After January 1st, 2026, a malfunctioning refrigerator could be considered a breach of warranty of habitability. The law does permit a tenant to choose to use their own refrigerator, but this must be documented in the lease, and you cannot require them to do so. A tenant can also change their mind with proper notice, which would then require you to provide the appliance. When it comes to stove, there is no opt-out. The landlord is required to supply it now. So what's the game plan? First, it's wise to audit your properties to identify every unit that doesn't have a landlord-supplied stove and refrigerator. Second, consider budgeting now for the purchase, delivery, and installation of these appliances before leases come up for renewal in 2026. Third, update your lease agreement to reflect these new requirements. Documents and conditions of appliances with photos at move-in, and if the tenant opts to use their own fridge, ensure the agreement is clearly written and compliant with the law. Beyond appliances, the state is also taking steps to address indoor climate conditions. This next development is more about future policy, but it establishes an important direction for housing standards. This is Senate Bill 655, which creates an official state policy to ensure all residential units can maintain a safe maximum indoor temperature during extreme heat events. Let me be clear about what this bill does and does not do immediately. As of today, Senate Bill 655 does not impose mandatory temperature limit on every existing rental unit. You are not required to rush out and retrofit every apartment with air conditioners tomorrow. What the bill does do is establish a maximum indoor temperature as a matter of state housing policy. It directs state agencies like the Department of Housing and Community Development to incorporate this into future regulations, particularly from 2027 onward. For those involved in new construction, the direction is clear. The law instructs the state to develop and propose standards for the next building code update that require newly built homes to maintain a maximum indoor temperature of 82 degrees Fahrenheit. This is a common legislative pattern. First, a policy is established, then it's applied to new construction, and then the final step is often to apply it retroactively to existing housing stock. Landlords with older buildings in Sacramento should see this as the beginning of a long-term conversation about mandatory cooling. The potential cost to retrofit older multifamily buildings with central air or even adequate window units and the necessary electrical upgrades could be substantial when that happens. This is a significant long-term planning consideration being introduced into law. The next update is focused on a frequently disputed area of the landlord-tenant relationship, the security deposit. Assembly Bill 414, which took effect on January 1st, 2026, aims to modernize the process of returning security deposits by incorporating electronic methods. On the surface, the rule is straightforward. If you accept the security deposit or rent payments electronically, you are now required to offer to return the deposit electronically. This changes the standard practice of only issuing a paper check for landlords who accept digital payments via platforms like Zelle, Venmo, or direct deposit. The compliance details are important here. If you wish to use a paper check for the refund, you must first obtain the tenant's agreement in a separate written document. If you send the check without this written opt-out, you could be out of compliance with the new law. The law also adds a new consideration for households with multiple tenants. It requires you to return the deposit in a single payment made out to all adults on the lease, unless you have a written agreement that specifies a different arrangement. This could present a logistical challenge for former roommates who have moved to different locations. While Assembly Bill 414 does allow you to email itemized deduction statements with the tenant's consent, the entire process becomes more structured. A simple oversight like failing to get a written opt-out for a paper check could create an opening for a tenant in a dispute over deductions and potentially lead to penalties for wrongfully withholding the deposit. Your move-out checklist will need to be updated. It's time to review your procedures and be meticulous in how you handle refunds, especially for multi-tenant leases. I had a client fined heavily last year by a small claims court for not returning a deposit fast enough, so this is a real potential issue. If you're finding this breakdown valuable and want to stay ahead of these laws, please take a moment to hit the subscribe button. We produce regular updates like this to help you navigate California's changing rental landscape. The aftershock and new burdens for natural disasters. In addition to tenant management, the state has also clarified landlord responsibilities in the aftermath of natural disasters, with wildfires, floods, and earthquakes being recurring issues in California. Senate Bill 610 outlines new specific duties for the landlords. First, if your property is affected, you are now responsible for removing disaster-related debris. Second, you must stop charging rent and other fees during any mandatory evacuation period. And third, the law codifies the tenant's right to return to the unit at the same rental rate once the property is repaired and deemed safe, unless the tenancy is legally terminated for other valid reasons. This adds a layer of financial planning to disaster recovery while you're managing insurance claim, contractors, and the stress of a disaster. You now have the added legal duty of handling rent abatement and securing tenants' right to return. This can affect the timeline and process of final recovery and may lead to disagreements over when a unit is officially habitable again. This is a good time to review your insurance policies in light of these new state-mandated responsibilities. Make sure you have loss of rent coverage. Finally, let's discuss a significant topic on the legislative horizon, rent control. The current statewide rent cap, AB 1482, which limits annual increases to 5% plus inflation with a 10% ceiling, remains in effect until its scheduled expiration January 1st, 2030. However, it's important to be aware of proposals for what might come next. It is also important to become politically active and let your state representatives know you don't want this type of change. You should also carefully read upcoming propositions on the ballot because this method has been tried 3 times in the last decade to try to make rent control more restrictive. A bill to watch is Assembly Bill 1157. This proposal, which did not advance previously but may be reconsidered for the 2026 legislative session, seeks to make major changes to statewide rent control. As written, AB 1157 would lower the allowable rent increase to just 2% plus inflation, with a maximum cap of 5%. This would substantially reduce the allowable annual rent adjustment. The bill also proposes removing the current exemptions for single-family homes, condos, and ADUs, which would bring nearly all private rental housing under this stricter cap. Furthermore, it proposes removing the 2030 sunset date, which would make the new rent control rules permanent. This is the next major legislative discussion in this area. It represents a significant potential change to the financial model of owning rental properties in California. This is the stated goal of a movement seeking to reshape the rental market. Staying informed about Assembly Bill 1157 or possibly helping to block it is very important for a landlord's long-term profitability. The legislative landscape for landlords is clearly evolving in 2026. You now have new responsibilities as an appliance provider under AB 628. You're being asked to plan for future climate standards under SB 655. Your security deposit process is subject to new procedural rules from AB 414. You have newly defined financial duties after disasters because of Senate Bill 610, and a more stringent form of rent control being proposed with Assembly Bill 1157. These laws are part of a broader policy directed in the state. Each new law adds a layer of cost, a new area of liability, and other reason for small landlords to carefully evaluate their business operations. This can contribute to housing being consolidated into the hands of larger corporations that have resources to manage these complex regulatory environment. Remember, I'm not an attorney and this video is not legal advice. It's for informational purposes only, to make you aware of the legislative environment we all operate in. To help you navigate all this, I'll put links to the full text of these bills in the descriptions below so you can read them for yourselves. Stay vigilant, stay informed, and protect your investments.